sensitive concerning the children. Keep that in mind and then just try to avoid use of their names. I don't believe we've had anybody file a motion asking that anything be excluded from the internet. So if you'll just kind of keep that in mind as you're making your argument that it is going out there on the web. Call the first case, please.
Reiss et al. Versus Rock Creek Construction, Inc.
We'll hear from the appellant.
Good morning, Your Honor, and may it please the Court. Paul Tennyson with Cole Law Group from the Williamson County Bar on behalf of the appellants Rachel Reiss and Thomas Camellia. I request to reserve 4 minutes of time for rebuttal, please.
4 minutes, that'll be fine.
Thank you, Your Honor. This appeal is about appellant's claim under the Tennessee Public Participation Act to dismiss the frivolous defamation claims filed by the appellee, Rock Creek Construction. The TPPA is Tennessee's version of the Anti-Strategic Lawsuit Against Public Participation Act, passed by the Tennessee legislature in 2019. The TPPA is intended to provide an additional substantive remedy to protect the constitutional rights of parties, and this is found at Tennessee Code Annotated Section 20-17-109. The Tennessee Public Participation Act allows a party to move to dismiss legal actions filed against them in response to that party's exercise of the right of free speech. The TPPA defines the exercise of free speech to include a communication made in connection with a matter of public concern. A matter of public concern includes, among others, a, quote, good, product, or service in the marketplace, end quote, or any other matter deemed by the court to involve a matter of public concern. First, a brief background of the relevant facts. The appellants, Rachel Reiss and Thomas Camellia, hired Appellee, Rock Creek Construction Incorporated, to construct a custom-built home on the property they owned located on Nature Lane in Knoxville. Unfortunately, the parties encountered a dispute. As appellants assert, Appellee breached the contract first through unsatisfactory performance, including numerous unnecessary delays. The custom-built home construction was never finished by Rock Creek. As appellants were dissatisfied with the level of service provided by Rock Creek, they posted their truthful, experienced, and opinion-based review of Appellee on the internet. These internet-published postings are similar to the Yelp review that was subject to the TPPA claim in the Nanogram case, which is Nanogram Neurology, PLC versus Beavers, 639, Southwest 3rd, 651. Rachel Reiss first filed a claim against Rock Creek for breach of contract in the General Sessions Court of Knox County on March 16, 2020. That claim was removed to the Circuit Court. Rock Creek then brought a counterclaim for defamation. Appellants believe Rock Creek's defamation counterclaim was frivolous and in response to their exercise of the freedom of speech regarding goods or services in the marketplace. Appellants thus filed a partial motion to dismiss and petitioned to dismiss defamation claims pursuant to the TPPA on May 11, 2021. Appellants supported their TPPA petition with declarations, sworn testimony under the penalty of perjury. Due to the local rules in effect in Knox County Circuit Court at the time of these events due to the COVID-19 pandemic, none of the motions filed in this case ever received an actual hearing in court. They were all decided on the papers alone. The trial court finally ruled on the appellant's TPPA petition on November 29, 2021. This appeal followed. Appellants argued today that Appellee's defamation counterclaim is frivolous. The appellants posted online complaints regarding the shoddy construction completed by Appellee. Appellants' posts were truthful, did not cause Appellee any actual damages, and were directly regarding a good product or service in the marketplace. Here, that would be custom home construction services provided by the Appellee. Thus, appellant's TPPA petition here involves precisely the type of conduct that the TPPA was passed by the Tennessee legislature to prevent. These facts are demonstrated in appellant's TPPA petition and their declarations in support found at the technical record pages 78 through 100. Today, appellant argues the trial court erred in denying appellant's partial motion to dismiss pursuant to the TPPA for several reasons. First, upon review of the trial court order does not reference the petition at all. The trial court rules only under the Tennessee Rules of Civil Procedure, not following the procedure specified in the TPPA. Second, there is no conflict between the TPPA and the Tennessee Rules of Civil Procedure, so the trial court's review only under the Tennessee Rules of Civil Procedure was improper. The timeliness of Appellant's TPPA claim was waived by the appellee's failure to raise that argument at the trial court. Appellant's public statements regarding the goods or services of Appellee in the marketplace is a matter of public concern under the TPPA. Appellants met their burden as the TPPA requires through their filing, which was supported by sworn testimony in their declarations. Appellee, on the other hand, failed to meet their burden to respond as the TPPA requires. In fact, Appellee failed to respond in any manner for over 7 months while Appellant's motion was pending. Your Honor, Appellee argues there's a conflict between the Tennessee Public Participation Act and the Tennessee Rules of Civil Procedure. However, Appellant asserts there is no conflict because the TPPA is a substantive remedy and the Tennessee Rules of Civil Procedure provide only procedural rules. Appellee argues about federal courts ruling on the TPPA. However, Appellant asserts this is unpersuasive. Federal courts must follow the Erie Doctrine, and that is not present here when we're talking about Tennessee state courts following Tennessee rules. Appellee only argues that the TPPA dismissal should not apply and has no argument that a dismissal is improper when the TPPA is actually applied to the facts of this case. In further detail on the 60-day rule, the 60-day deadline to file a TPPA petition after litigation began should not apply in this case for several reasons. First, Appellant argues that Appellee waived the right to bring this argument for the first time on appeal. Next, the motion to dismiss by Appellant was filed on May 11, 2021. The trial court did not rule on the TPPA petition until November 29, 2021. This means for over 7 months, Appellee was on notice of the arguments made by Appellant and failed to object to the motion on the basis of timeliness or the merits of the TPPA petition. The statute provides very clearly that the court has discretion to hear a TPPA petition filed after 60 days. Since the lower court did not reference the timeliness of the petition under the TPPA, the lower court declined to rule on this discretionary issue to allow Appellant to file the TPPA petition more than 60 days after the litigation had began. Your Honors, as this court is familiar, issues of statutory interpretation are reviewed de novo. That includes whether this involves a matter of public concern. Appellant was speaking truthfully about their experience with the service in the marketplace within their community. Appellee conducts business within the community, and therefore a review of Appellee's service is a matter of public concern. This is similar to leaving reviews on Yelp or Amazon or other things where consumers can say how satisfied they are with a product or good or service. The Court of Appeals has previously rejected the argument that goods or services critiqued must relate to the community as a whole, and this is in the Doe case. Doe versus Roe, 638 Southwest 3rd, 614. In Doe, the court determined that allegations of sexual misconduct is something that affects the community as a whole. Regarding the merits of the TPPA petition filed by the appellants, appellants met their burden. They were able to show that the action, the counterclaim for defamation filed by Rock Creek, related to or responded to their right of freedom of speech, according to Tennessee Code Annotated Section 20-17-105A. As was discussed earlier, Your Honors, it's a matter of public concern, which is a discussion of goods or services in the marketplace. Additionally, appellant's statements were truthful, and Appellee had no proof of damages. All Appellee says is, very conclusively, we were damaged. That's insufficient as a matter of law. Once appellant met their burden pursuant to the Tennessee Public Participation Act, the burden shifted to the appellee to respond. However, appellee did not respond. Since they did not respond, they were unable to establish a prima facie case for each essential element of their defamation claim in this legal action. Your Honor, another argument that's brought up in the briefs is regarding requests for admissions. Appellee asserts that this appeal should fail because appellants did not seek to withdraw or amend their admission pursuant to Tennessee Rules of Civil Procedure 36.02. However, the technical record at pages 47 through 66 shows that appellants did file a motion to alter or amend the trial court's order dated March 23, 2021, and the order entered on February 3, 2021. The appellants supported that motion with sworn testimony in their declarations. Appellants specifically requested the trial court to vacate those orders and allow them 10 days to file responses to the request for admission submitted by appellee. The trial court did not rule on those pending motions until after ruling on appellant's TPPA petition. Your Honor, today appellant is asking this court.
Let me ask you a question here as time runs out. Trial court found that admissions had been deemed admitted.
Yes, sir.
By your client. I mean, these were admissions like that Rock Creek, that the trial court found that the Rock Creek didn't breach the contract, that your client did, that Rock Creek suffered damages. I mean, does that address the What does that do to the argument you're making, that these were factual admissions and truthful and there were no damages? And, I mean, if the trial court found that this had been admitted, is the trial court wrong on that?
Well, Your Honor, when looking at the factual basis of the argument, appellants did argue that they never received the request for admission that were supposedly provided by the appellee. So appellant's argument to the trial court was, we never received notice of this. I guess what helps with this background a little bit is that appellants were represented by counsel previously. That counsel withdrew. They were proceeding pro se. At the time they were proceeding pro se was when this discovery was issued by Appellee, and appellant says they never received it. They hired new counsel, and so one of the first things the new counsel did was file a motion to alter or amend. So I think the best argument from appellant's perspective, Your Honor, is that they had filed a motion to alter or amend, and that matter was still pending at the time of their TPPA petition. So there wasn't a final order by the court regarding these requests for admission at that time, as they'd filed a motion to alter or amend that had not been heard.
Trial court denied the motion to alter and amend before granting Rock Creek's motion, correct?
Your Honor, my memory of the timeline found in the technical record is that the court first ruled on the TPPA petition. That was the first order issued by the trial court. And then immediately after that, the court denied the motion to alter or amend by the appellants. Those orders were issued on the same day.
You're not appealing the motion or the denial of the motion to alter or amend, are you?
No, Your Honor. Our appeal was solely about the TPPA petition.
Well, following up on Judge Sweeney's question, since those admissions they're now have been established and deemed admitted, what does that do to your argument?
I mean, I would say that the argument remains in the fact that under the TPPA, they still have a burden to respond. So we filed our motion under the TPPA to dismiss, and Appellee did not file anything in response. If they had filed a response that simply said the trial court has already found this, then they could argue that. However, as there's no response filed, I think the best argument here for Appellant is the argument remains, Your Honor. I see I'm out of time. Thank you.
You have your time for rebuttal.
Thank you.
Thank you. We'll hear from the appellee.
Your Honor, John Dupree from the Knoxville Bar for Rock Creek. Just start by saying Mr. Tennyson has had a tough job coming into this case late in the game. There'd already been a major cage fight in Sessions Court and through the beginnings of the Circuit Court case. But I would just point out some of the things that were established before Mr. Tennyson was able to get involved. This went well beyond one post on the internet. The appellants fired my client when the house was almost complete after an extended period of rainfall. They breached the contract. They repeatedly called and texted the manager, and if the request for admissions were in the record, it would show it would be hundreds of times, but they're not. But they used foul language. They threatened to come to his house. They threatened to tell this manager's 13-year-old son, pardon my French, what a bitch my client was, or the manager was. They challenged this manager to call the police. They told this manager they were going to nitpick every little thing on this house. They told this Rock Creek that they were going to drag Rock Creek in and out of court, and it's going to be Rock Creek's reputation and money, and they were going to rack up Rock Creek's legal fees. They said they were going to go onto the internet all night so that everybody knows what a slime ball my client is. They referred to Rock Creek manager as a thief, and the civil warrant even says is for theft. They posted pictures that were misrepresentations on the internet. They told this new contractor falsehoods about Rock Creek. They vandalized part of the home to increase the damages in their case against Rock Creek. They terminated the second contractor and again harassed him through phone, messages, and texts. They had to hire James Bell to represent them. Mr. Hollow came on board at one point, David Hollow, well-respected attorney here in town. He withdrew after a very short amount of time. And, because this case was a construction case about, what happened at the house, we transferred it to circuit court. And I sent over standard discovery, request for production, things that you might expect in a construction case, and request to admit. The appellants ignored this discovery, so I filed an order, a motion to compel. There was an order entered on the motion to compel. I then filed a motion to deem the request to admit admitted. There was an order entered on that. And then Mr. Tennyson, unfortunately, came in to try to clean up the mess. I filed a motion for default and strike the pleading shortly after Mr. Tennyson, a couple of days after Mr. Tennyson got involved. I'd already prepared the motion. Then Mr. Tennyson filed several motions, but did not file a motion to withdraw or amend the request to admit under Rule 36. Finally, I filed a motion, a pleading, just trying to get the right order of all the things that had been filed. I asked the court to hear my motion to strike and motion for default first, and then depending on what happened, and that's at the record at 104. I asked the court, depending on what it decided, let's get a scheduling order for discovery, depending on the outcome of those motions. The court entered 3 orders. It was an order denying a motion to dismiss of the plaintiffs and under the TPPA, which is the only thing that's before the court today. It stated that Rock Creek provided statements made online to third parties that were defamatory and caused damages. It ruled under Rule 12, under a Rule 12 standard instead of the TPA standard, and denied their motion. It also entered an order on denying the motion to alter or amend.
Excuse me for interrupting,
Yes.
Counsel. With respect to the trial court's ruling on the motion to dismiss, could you address the appellant's argument with respect to the fact that your client did not file any response to the motion to dismiss?
Well, Your Honor, at that time, the request to admit it had already been deemed admitted, that they had made defamatory statements to a third party and that it caused damages. So at that point, it's much too late for them to come in and file declarations that dispute these already established facts. So that's the reason why, Your Honor. And in addition, I did file that the motion to line these things up. If my motion prevailed, then or did not prevail, then we would address their motions. And in fact, one of the things that the TPPA says is that I can file affidavits, up to 5 days before the hearing on the TPPA motion. That hearing was never scheduled, but I don't think it needed to be because the facts were already established through the request to admit.
Thank you.
Yes, Your Honor.
Assuming that, as counsel has admitted, the facts that have been established that were not on appeal that were admitted, what does that do to the TPPA claim? Can a TPPA claim be prosecuted with the facts, the established facts that we have in this record?
Well, case law, Your Honor, I cited in my brief was that once facts are established, and this is under the case law that I filed in my brief, once facts are established through request to admit, then you can't introduce evidence, declarations, or anything else in support of anything else that can't be disputed. And that's what happened with this particular case.
Well, I don't think I probably asked the question
Maybe
correctly.
I can't hear you. I'm sorry.
Well, can a TPPA claim be brought, assuming the facts that have been established in this case is it a legal impossibility to do that?
I think it's impossible under the facts of this case because the facts are established. In order to bring this TPPA claim, they're going to have to submit declarations or affidavits, as they did, in order to support this particular motion or petition. But the case law shows it's much too late for that. They can't, once the facts are established, you just can't unwind them from that point. So I think the TPPA claim is no good at the outset. I hope that answers the court's. Okay. Now, in my brief, I did say that the TPPA procedure is in direct conflict with rules 8, 12, and 56 because it decides whether a claim can be dismissed pre-trial. And the case law is clear that outside the it's not clear, but I cited this federal court Apex Bank case that actually looked at the TPPA and its conflict with federal rules of procedure 12 and 56 and decided that the TPPA procedure cannot be used in federal court because it's in direct conflict with the federal rules of civil procedure. And, they're not identical, not precisely identical, but we've been doing this a while, and we know what Rule 8, 12, and 56 are all about, and this TPPA procedure is in direct conflict with Rules 8, 12, and 56. And in fact, the TPPA itself incorporated a severability provision at 2017-110, which we do in contracts and agreements that if something doesn't work, why, the rest of it's okay. They actually put that in here, anticipating that there's going to be a problem with this procedure. So I think it is in direct conflict, and I think it is a problem for the TPPA in the way it's done. They could have done it differently. They could have just said, well, the winner that prevails, they could have made a statute that said the winner that prevails in a slander or defamation case can get attorney's fees and address it that way. But they didn't do it. They decided to do it this way. And I cited case law from federal court, the things that are published out there on why this is a problem. And
I understand, excuse me for interrupting, the trial court in this case addressed the motion to dismiss by using a Rule 12 analysis. Is that correct? That's
correct, Your Honor. I think he did it the right way. And in fact, the trial court below cited Exhibit 1 to the counterclaim about the online posts. It cited facts in the counterclaim. It showed that the plaintiffs, and it held that the plaintiffs intentionally held up Rock Creek public contempt and disgrace. Now, is this a public concern? We've heard some arguments and discussion about that. This is not a public concern. This is a personal vendetta, and it's not a public issue. There's been no evidence before this court, and there's nothing before this court saying there's a whole host of people that depend upon the outcome of what these folks said. That's not there. This is not a public concern. In addition, I did mention that they didn't file within 60 days after they filed, after the counterclaim was filed. I don't believe that particular claim or argument is waived, because I did file my motion saying, hey, let us line this up and see how it works at the record at 104, where I was just saying, give us a scheduling order so we know how this is going to work. But the court went ahead and decided it without setting it for hearing. The appellant cannot and should not supplant the Tennessee Rules of Procedure with this procedure in the TPPA. It failed to ask to alter or amend the request to admit. The facts were established by the time that their motion was filed, their petition was filed. It can't come in later and dispute these facts with declarations. The trial court found third-party statements online can be defamatory in its order. This is not a public concern. A substantial number of people in public are not affected. This is a private dispute between private entities and individuals, and calling it their opinion does not make it so. The question is, would a reasonable person think that there are verifiable facts establishing that my client is a thief or did defective work? And the trial court apparently agreed. This trial court's order should be upheld. Thank you, Your Honor.
Here's the appellant rebuttal.
Yes, Your Honor. One of the issues raised by Appellee's argument is about damages for defamation. Appellant argues that damages have to be actually proven in Tennessee, and the request for admission is insufficient to prove damages. Admit that you damaged us is not sufficient as a matter of law to show damages for defamation. There was never a hearing on the TPPA petition, and if you look at the language of the statute, the TPPA, it clearly does anticipate there being a hearing where parties are present and able to participate. Your Honor, I think it's an excellent question about whether the claim can be brought under the facts of this case. Appellants would assert that the TPPA facts are different than the facts that were requested to be admitted by the appellee. For example, under the Tennessee Public Participation Act, the party bringing the petition has to show that the filed action relates to or responds to their request of freedom of speech and has to show that it's related to a matter of public concern. Those facts were not established in the record by the requests for admission that were requested by the appellee.
Well, counsel.
Yes, Your Honor.
The trial court found these admissions had been deemed admitted, no breach of the contract by Rock Creek, no damages been incurred by plaintiffs, that Rock Creek had suffered damages as a result of plaintiff's breach of contract in the amount specified in Rock Creek's invoice, that plaintiffs knowingly made false statements to third parties, and that Rock Creek was damaged as a result of these defamatory statements. I mean, what else would a party have to do to show that the TPPA action should be dismissed?
Well, Your Honor, under the...
If
Yes,
the
Your
facts are that they made false statements.
Yes, Your Honor. I see the point the court is making here. I'll just go back to the burden shifting framework in terms of the fact that the moving party has to first show that the TPPA applies, and then the court shifts the burden to the appellee. If you look at the language of the TPPA, it asserts that they have to do something in response. And appellant's argument is they did nothing in response. They had 7 months where they could have simply filed, we incorporate the request for admission that were found by the trial court. They didn't even do that, Your Honor. So that's appellant's view of it, is that those facts that were established by the trial court did not conclusively determine all of the issues that are before the court in a TPPA petition.
Well, isn't your whole theory based upon a breach of contract?
Your Honor, so...
That the builder didn't do what the builder was supposed to do, correct?
So that was their claim originally, Your Honor, yes. The only claim that my client, Rachel Reiss, brought at the beginning was a breach of contract claim. Yes, Your Honor. In response to them bringing a breach of contract claim, though, Appellee decided to assert the defamation claim, which is why the TPPA arose in this case from appellant's perspective. Your Honor, Appellee argues about federal court cases.
Assuming the trial court found no breach of contract, which it did, and that's not on appeal.
Yes, Your Honor. You're correct about the breach of contract.
What does that do to your TPPA claim?
Your Honor, our argument is it survives because the TPPA says it can be brought in response to a legal action that is brought regarding free speech and other things under the statute. So regardless of the original claim that was brought, they would still have a TPPA claim because there was a counterclaim brought by the appellee. If appellee had not brought a counterclaim.
What is the basis then of your TPPA claim?
Yes, Your Honor. I believe it is in response to the defamation counterclaims brought by the appellee. They then have the ability to petition under the TPPA. Is that satisfactory answering your question, Your Honor?
It may be the best I get.
Yes, Your Honor. I see that I'm out of time unless there's other questions.
Court, I hear no questions. So, of course, thanks to counsel for both sides. We appreciate your oral argument this morning and your briefs in this matter.
Thank you, Your Honor.
Thank you. Call the next case, please.